Morning, Nina.
Hi Andrew, how are you?
You're wearing the winter clothes?
It's freezing in Melbourne now. I think it's high of 13 degrees today. So please feel sorry for us wherever you
I was
are.
just trying to explain the toy wind chill factor because yesterday
Oh,
it was 9 at home, but when I walked outside, it felt like about 3 or 4 because the wind was just whistling through it. It was just awful.
still not as
Anyway,
bad as when you sent me to Tamworth. 2 degrees. 2 degrees.
I didn't deliberately send you to get cold. All right, well, look, we've got a lot on today. We're going to have a talk about some of the interesting things that have come out of flexible work a little bit later and show some of the perverse results of studies as well as some of the more obvious ones. And also talk more about the open solutions for working and what actually is happening and what is not happening, because I think financially it's a great result to have people working part-time effectively at work, and it's great to have hot desks, but how's that affecting the performance of work? You won't be surprised with the results around that.
No,
But look, let's just jump into our first case, okay? And our first case is dealing with
valid reason.
valid reason.
I think this one was really interesting because the employer actually summarily dismissed the employee for a whole raft of different reasons. Stuff like he concealed the tool they were supposed to return. He sent abusive
Text,
texts
yeah.
to his supervisor. And get this, it was a work vehicle, but during a period of leave, he racked up like 6,000 kilometers going to pubs. So just crazy,
Is
crazy
it
stuff.
6,000? I thought it was 600. I reckon you've exaggerated.
Oh, okay, so 600. That's still a lot.
Dana, winding it up.
Was like a couple of days. And his defense for all of this was like, oh, I actually don't think I should have been back at work. I'd been off for a couple of days due to mental health, and I don't think I was in a fit state to return. And the commissioner jumped on that and said, well, actually, irrespective of what the reasons were for your termination, that in itself was a valid reason because you placed a huge safety risk. And the only reason you return is because you didn't want them to take your car away.
That's right, isn't it? So
Oh my
he
gosh.
returned to work saying he was fit for work on the basis that he wouldn't lose his car.
Yeah. Which was a work car.
But I think the fact is, it just shows you that sometimes you don't get the valid reason right in the termination process, but there is an underlying reason, which is absolutely true. For us, the lesson from this case is to step back and not respond to the minutiae and look at what is the big issue.
Yeah, I think that's a really easy trap to fall into, particularly with employees who've been basically annoying you for a long period of time.
Yeah, the red flag employee, the person who's driving you crazy, and suddenly they do something, you go, that's it, line in the sand.
And you want to put everything in.
Yeah, and all you need to do is red flag employees do wrong regularly. It's a safe place. So you just need the good reason. Yeah. Don't jump for the person who was 2 minutes late to work. No. Wait for what there is a good reason. So let's jump on to our next case, which
is updates to reportable conduct scheme. So I think it's not a big change.
So this is a child reportable conduct scheme. So this is under the Child Safety and Wellbeing Act. Is that right?
Yes, not quite the title, but yeah.
I nearly always get it nearly right, don't I? Is it child wellbeing and safety?
Yeah, it's hard. I can't remember it. It's CYSA, I think. Child Youth and Safety Act, I think.
There you go.
But yeah, administered by the Commission for Children and Young People, and the basic changes is it's expanded who counts as an employee for the purposes. So it'd be contractors, any labour hire, also directors of any companies that would work with you. Because previously, for anything to be a breach, it has to be in relation to actions by one of those employees. So it's quite narrow. It can
be a volunteer as well. Which right. I think when we look at child safety and we're looking at places like schools, we're looking at organisations which provide health service or things around child wellbeing. Almost all those organisations have either some philanthropic limb to it, which means there are a number of volunteers, or in schools there are parents who undertake voluntary work. So there's a whole range of people you wouldn't think of as employees, and this legislation sweeps them all up and says, well, they are.
Well, volunteers are already included, but like volunteers engaged by labour hire are now included. So they've expanded that, yeah.
Okay, very, very good. Why don't we go on to, I think,
insufficient notice
case, because I think this is a this is a fascinating case. We often talk about what is a genuine redundancy, and remember, a genuine redundancy is a threshold test when you do a redundancy, and there are a lot of factors. Have you provided suitable redeployment?
Yep.
But this is an expansion on the offer of suitable redeployment, isn't it? So, do you want to talk through that, Nina?
Yeah. So this was a case where they made an application to reduce the redundancy payable to 2 employees to 0, because they said they had offered them suitable alternative employment. They were 2 FIFO workers from WA, and they had offered them a different roster, which would require them to spend a lot more time travelling and away from their families. So both of those offers were declined.
So can I just say, so the first stage was it a reasonable offer of redeployment? And so at that stage, the commissioner also found that that was not reasonable. But the major reason was the next part, which was
the fact that the offers had only been given to them about 10 and 11 days prior to the redundancy taking effect. So there wasn't sufficient time for them to properly consider the changes in roster or to make alternative arrangements in their own personal circumstances to accommodate it. So that in itself made it invalid and not a reasonable alternative employment.
So can I just say, this is one of the major things in redeployment cases, particularly where you change timing, is that people do have personal carers responsibilities.
Yeah, and family responsibilities as well.
So at that stage, you've got to go, all right, well, how can who's going to pick up the child from school? Who's going to do what? And so when you change it dramatically, the notice period has to be sufficient to allow the people to meet the job.
I think it's particularly because this case was a FIFO arrangement. It probably wouldn't, I think 10 or 11 days in a regular job, like one of our jobs, would be sufficient to accommodate that.
Let's give an example. So maybe they were a teacher at a school, and they said, look, the job no longer is required. We do have an afternoon program we could run, and you can do that job. And the teacher goes, but I work at the school and I drop my child off on the way to school and I pick them up on the way home, and I'm a single parent. I'm not able to actually drop the child off at 2:00. So to make those alternative arrangements will take some time. I'll have to call upon other parents, other family members. So it's that adjustment that needs to be made if they don't get sufficient time. So where you're moving times or dates on people, you've got to get behind people to allow them to adjust to their personal circumstances, and you must make inquiries about their personal circumstance. Otherwise, you have bigger risks as well, like discrimination law.
Yeah, but I think this could be handled through consultation. It's not that there's a specific period that you have to give people, but it would be that during the consultation process, you're having a couple of meetings with them to say, look, if this is possible, if you need more time. That's all about that consultation.
Yeah, and remember, there's 2 parts to consultation. One is the town hall style of meeting that describes the change and what the opportunities are. Then there's the individual consultation that flows from that, where the decision has been made, which is what you have to do under the award. You've made a decision to actually terminate someone's employment or to provide them with suitable alternative employment. At that stage, you've got to have careful individual consultation around what happens. Anyway, look, I know we're always interested around this area, aren't we? Because the law is ever evolving in it. I reckon the franchising one, which is our next case, is a killer, don't you?
I think that's probably the biggest case.
So,
I think.
Just to give you a bit of background, around about 3 or 4 years ago, 7-Eleven, as a major franchisor with huge amounts of franchisees, had knowledge of underpayments being made by franchisees and did nothing about it. And there was really no coercive provisions that exist under the Fair Work Act to deal with it. So after that, it was rushed through Parliament, the 7-Eleven ones, which had the coercive high penalties, high risk provisions. And this is the first case that actually uses those 7-Eleven changes to deal with known underpayments and a deliberate underpayment process. So now, do you want to talk through the facts a bit?
So I'll kind of lay the landscape a bit on the law first. So after the 7-Eleven cases, they introduced what's called a franchisor responsible franchisor duty, basically. And that meant that certain responsible franchisor entities, so if they had a franchise, they had franchisees who were substantially connected to their IP, and the franchisor had significant control over the franchisees, then they would fall under this and would have this duty, which meant that they had to take reasonable steps to prevent underpayments if they were aware of them, basically.
And so most franchisors derive a certain amount of profit, percentage of gross profit, usually, or net profit that comes out of the business, and therefore they are able to drill down on the figures they receive to see what are the wages costs, and under those circumstances, you just apply a model to it and go, that seems low.
Yeah, like obvious red flags kind of thing.
Yeah.
But this one was very unique because 85 Degrees Coffee used to be a franchise itself. So it has a whole history of underpayments, I think, between, it was like 2009 and 2014.
It ended into enforced
undertaking. So. That was the first one. It entered into enforced undertaking for huge underpayments and record keeping failure. And then after that, a couple of years later, had even more underpayments and got convicted and fined $475,000. Then decided, you know what, let's become a franchisor and we'll like pass on the liability to our franchisees. Then 8 franchisees underpaid their employees. They've also been done by. So that this duty doesn't mean that the franchisees are not pursued.
Yes.
They have their own cases. And then the franchisor in this case got imposed with a $1.44 million fine, and he now has to shut down and they're leaving Australia.
Yeah. So look, I think we see it in all franchisors who are dealing with high volume, low price turnover goods. So the classic types of 7-Elevens and other shops and coffee shops and restaurants that are done, undertake this process, there is always a temptation to underpay. And I think when my kids, my 4 older kids, their first job were at well-known and established takeaway places, which repeatedly failed to pay in accordance with the award what was done, and sitting there as a dad and saying, you realise you are being underpaid, and they said, shut up, Dad, I just want the job. But I want you to understand this is pervasive, but these provisions now are such that any franchisor who has needs a bit more than constructive knowledge. It needs a deliberate knowledge of the wrong that is being done, but that can come through having access to data that places them on notice.
Yeah, I don't think
I think that's what Bromwich said.
Yeah, it doesn't have to be knowledge of the deliberate wrong, but if there is reasonable suspicions that you should have inquired further, then that would meet the test. But you're right, the courts have not yet accepted constructive knowledge, but I reckon it's a matter of time.
Yeah, I think so too. All right, well, let's go on to flexible work and workplaces. Now, there's there's a really interesting study that was done.
Defamation.
We're going bad. That studied 77 employees and showed that they had problems when they were actually at work because the ergonomics weren't good and they were sitting in hot desks.
Yeah.
This is the precursor to a conversation I'd like to have, which is a bit broader, which is what we're seeing across all workplaces, and unfortunately also with our children, is a dramatic decrease in people's concentration capacities and time of concentration capacities because of things like access to social media and phones being almost like a part of your body, through the flexibility work, through working in open work environments where there's constant noise. And what people have become adjusted to is they can do tasks really quickly, easily, but the deeper thinking tasks they really struggle with. And so organisational psychological data coming in shows that open offices, wait for it, are not working that well, and that people do need private proprietal spaces which they feel their own, so they can.
There's a connection.
That's connection, and the phrase that is used is so they can maintain a flow, so that they get into a place where they're thinking and feel safe and can be deliberate in what they're doing, and over time their concentration will grow and expand in time, and the deliberateness of their behaviour. But as we see with the virtual world, we're having people coming in, they hot desk, they don't have any connection to the person who's sitting next to them.
Sometimes they spend ages just trying to find the desk because and sometimes they want to come in, they can't because there's not enough desks. Yeah. The hot desking is crazy.
So the savings you get on leasing by having less desks and the same amount of people, having people working from home, and the abundance of workers' comp claims that are now coming from people being injured at home, and the neuropsychology of knowing that you can't have meaningful and deep conversations with people virtually, So I can't, when I'm chatting to Nina on Teams, see if she's worn out, tired, or unhappy. All I can see is the Nina I see on the screen, which is effectively two-dimensional.
Does it stop you from commenting if I look tired?
No, it doesn't. It doesn't. But that just shows that I'm socially irresponsible. But if I want to work on something really hard with Nina that's clever, I know I've got to be with her, because that way we actually get things done which we can't do virtually.
Mm-hmm.
So we've found ourselves in a world where we can't get full-time employees to come to work full-time who are highly skilled, because they won't do it anymore. Yet in complex, clever jobs, you need that collegiality to have the best outcome. So we are caught in a proper catch-22.
Yeah.
But what I want to do is remind people, don't think open spaces answer it. Hot desking definitely fails in relation to concentration and the delivery of work. And the virtual world needs greater constraints and deliberate actions taken around quality of work and what work looks like at home. Because at the moment, people working from home do a whole range of things, including work.
Yeah.
So that concentration, the breach of flow is significant. So we thought we'd just raise that as a policy issue going forward, which we'll keep coming back to. All right.
I think we're on to the main topic.
We're on the main topic now? I think we are safe, aren't we?
Oh, no.
No, stay. No, come back with interrogative team. I reckon this is a great case. So this is a case. So let's talk about bullying. Three.
Yeah, but we're going to talk fast because we're running out of time.
Are we running out? Okay, bullying, 3 elements.
Yep.
Repetitive in nature.
Directed at a group or an individual.
Yeah, that just. I'll have my 3. You can have an extra few. All right. He's unreasonable. He's unreasonable in relation that it hurts, humiliates, or intimidates.
And it's an objective test.
Yeah, that's what reasonable means.
Yeah.
Come on, you're pulling the carpet on me today. And finally, without any embellishment, it makes someone's work unsafe. All right, that's bullying. Bullying is a really high test. Okay, so lots of behaviour which is misconduct or inappropriate or not as good as it could be doesn't make it bullying. And I just want to be clear about that. And the facts in this case, I reckon, I'll let you do the facts because you're better at it than me in this case, but it's really a range of Teams messaging, isn't it?
Yeah, it was. They were claiming that there was micromanaging. So the IT employees said that their team leader was micromanaging by asking about their work. An example provided was, "Can I work from home today?" And the IT guy asked why, and he said, "Oh, because you said I could on Thursdays, and I've not really done it." And he was like, "Oh, okay, cool, sure." That was micromanaging, he said. And
what about the questioning though?
That was the questioning.
No, team leader.
Yeah, here, this is the example.
Work from home. Oh, I thought that was.
No. It was just
that was WTF.
No,
it's WHF.
No, it's just about asking about working from home.
Gee, that's
and he thought that was micromanaging, and then he brought a claim against the HR manager.
I shouldn't scan.
No,
I should read, shouldn't
I? HR manager, because they gave him a warning for making a vexatious complaint. And in both cases, the commissioner found, look, while it's not ideal how things were handled, it didn't meet the threshold of bullying.
Well, WHF is a lot different to WTF, isn't it?
Yeah.
I thought that was a pretty tough case.
All right, on to the main
story. Okay, let's get on to the next case.
Oh, gosh.
All right. I thought in the last couple of weeks, I think Nina and I, and Kim as well, have had a number of HR and safety managers say to us, look, I'm in this really difficult position. I've been asked to do this and I don't know what to do. And all of us have said the same thing, which the current case law is increasingly identifying in HR and in safety. You're an owner of a body of knowledge. You know what is lawfully right and not, or you will with that title be deemed to have had that knowledge. And if you take acts which are inconsistent with that, then you have personal liability. All the cases we're going to talk about don't necessarily talk about personal liability, but what they do is destroy brands. So we've acted on a number of occasions where HR people have been named and as a result of that have lost their jobs and found suitable work in the future very difficult. And that's because of social media and because of the fact we do have Workplace Express up there naming people and doing things. So what we thought we'd do is, if we look at Northgate and Melco, which is somebody being told to dismiss somebody immediately.
Yeah. But with no reason, just get rid of them.
claim was successful by the worker, of course, but the
No, wait. But like the facts is the HR manager was told to dismiss someone, no questions asked. They did. Then the next day they got a complaint by someone else who'd been dismissed, no questions asked. And then the HR manager was dismissed by the CEO, no questions asked. And it was the HR manager who brought the claim. It's crazy.
Well, there you go. But the bottom line is that each part along the way, any litigious process, will name who the HR manager was. And in this case, they acted unlawfully themselves.
Yeah.
No repercussions there, but as we start to go down into Fair Work Ombudsman and DTF, which is the Din Tai Fung case, where the manager manipulated the payroll to reflect deliberately the underpayment to make it look right.
Yeah.
Then there was large personal liability, and I was going to be a fine. I think it was $100,000 fine or something like that.
Yeah, something like that, $100,000 or $150,000 fine, because they were clearly personally involved. But I think the more interesting case is the one involving underpayment with the NSH North, which was another underpayment, but the HR manager knew that what was happening was wrong and raised it with the general manager and said, look, I don't think we should be doing this. And the general manager said, just do it anyway. And they complied. And they tried to defend themselves and said, look, I actually did try to raise it, but I was ignored. And in my culture, it's very difficult to go against an older male figure, things like that. And the Fair Work Ombudsman who brought the case and also the court said, look, that's not a legitimate excuse at all, because if you know something's wrong, your obligation is to actually do what you reasonably can to stop it, not just raise it once and then keep engaging in the unlawful behaviour.
I know. And look, we also saw it. We're killing Sophie's trying to put up labels. We run between cases. But the Balderstone's another case where they tried to put a person on salary when they understood they were reward-based. And I guess the case that I always go back to is Fair Work Ombudsman Centennial. I'm killing you, Sophie. I know it's the second last case. But this is a case where the HR manager with the director knew that putting them on the contract as a contractor was not a lawful process. The HR manager said that. They knew when they didn't pay them for the work, that the training they were doing, that was unlawful. And the HR manager advised it but did nothing about it and was found to be personally liable along with the director. So there's a whole lot of cases that say flashing across the screen as we're moving, but they're all relevant cases that go to it. The case I haven't got in here, and it's my fault because I should have given it, is the OHS manager who became operational in a sense. They said, we've got a problem. And the name of it escapes me, but said, look, we've got this problem. We need to do a risk assessment, then didn't do a complete risk assessment. And as a result of that, an injury occurred. And the OHS...
Is that the vaccine one?
Yeah, I think so. And it's the OHS manager became personally liable and was prosecuted for it. So I guess the purpose of today, and we've really made Sophie's life hell while you and I have discussed this, is the courts now see this dedicated body of knowledge in professional people, in professions which weren't recognised as pure professions with a law around them, like HR managers and safety managers. That's over now, and the gloves are off. So for underpayments, mischaracterisation of people, trying to sneak things through, doing terminations that are wrong. Remember, in general protections, you can be brought as an individual and commonly are as an HR manager when you prosecute the termination. Liability is landing on HR and soon safety managers on a regular basis. So stick to your body of knowledge, advocate. Say that you're not happy with what's happening and that it's wrong.
Reasonable steps.
Take reasonable steps to stop it, and then if they wish to proceed from it, step back.
Yeah, because remember, under safety there's also reckless endangerment risk as well.
Okay, well, let's go to
the case
study.
All right, Max was not amused. Flexible work was becoming less flexible and more onerous as the management sought satisfaction that work was getting done. His boss, Angela, was a good woman, but struggling with her diaspora of employees across Greater Melbourne. That's so dramatic.
I know, I just put the word in for you.
They were in all the office and easy to supervise. The business was called Best Swap, an online trading business that arranged virtually for clients to swap goods and bid the difference in value with credit card payments. There was a mass of digital transactions, and the IT team needed to be ever present to fix any problems before people left the platform in frustration. Angela was head of IT, Max was her 2IC. His job was to maintain the system and allocate work to his team. Angela's grown tired with Max's two-word responses on Slack. Over the past few days, the platform had been wobbly. Angela had sent increasingly urgent messages seeking response to concerns about the vulnerability of the system. On Slack, the following communication occurred and reflected several past communications. Angela, what is happening, Max? Are you online? Can you see the coding issue? WTF. Is that right? From the other one. Max, respond. Max, cool your heels. I have a sick child and just needed to help her. Angela, sorry about Tiff, his child, but your job needs you now. Fix this immediately. Max, give me a break. Let me clean up Tiff. As Jen, his wife, has just stepped out. Angela, don't you understand, Max? If you don't fix this now, we'll all be out of jobs. Stop making excuses and do it. Max fixed it 10 minutes later and the system managed to stay afloat. He spoke to Hugo from HR, complained that Angela bullied him and doesn't appreciate the pressures of a young child. Hugo spoke to Angela and the CEO, Frank. They both said he had to go. Hugo explained the complaint he made and his personal caring responsibilities. They both said, sack him, Hugo, do it now. Hugo didn't protest. He arranged a Teams meeting, sent Max a show cause letter, and proceeded as best he could to provide procedural.
I'm glad you're not speaking quickly.
We have like 5 minutes left.
Okay, did Angela bully Max?
No, this was. Well, wait, it was repeated behaviour.
It was repeated behaviour, but I don't think even with W2F, not work from home, I think that that's not enough to be bullying. Okay, I think that there's a rigour around trying to get things in the sense of urgency in it, and his failure with it, not ideal, but I don't think it's bullying. Okay. So that's my view on that one. Was Angela's conduct a psychological hazard and breach of safety law? The answer is yes. So it wasn't bullying. It wasn't one of the bad 4, but it was certainly part of the bad 11 that sit underneath it, okay? Was Max's conduct in caring for Tiff during working hours a legitimate personal carer's responsibility and protected attribute?
Oh, that's interesting because you're not supposed to be caring for your children while you're at work.
But you've condoned it as part of work.
Yeah.
So I don't know what the right answer is because we need more facts, but can I just say to you, this is one of the real problems of working from home is people take on personal caring and family responsibilities and it's assumed as part of the role that that's okay.
Yeah, because they haven't taken the leave on it, but you're allowing them to do it. Yeah.
Okay, next question. God, there's more than I thought. Would Max have a good unfair dismissal claim?
No, not for an unfair dismissal.
No.
Because it's about valid reason and Oh, no, there's no valid reason.
There's no valid. Yeah. There's no valid. It has a great unfair dismissal.
Sorry.
Would he have a good general protections claim or discrimination? Less clear, can I just say? The unfair dismissal is the easy one.
But they're getting rid of him because he made a complaint.
Well, maybe they are. Maybe they're just sick of him being hopeless.
I think, but based on this thing, as soon as he made a complaint, the temporal connection, they would struggle. I think.
I don't think they do well, no. If Max had received a final warning and the impact of the disciplinary process left him with a diagnosable mental condition, would he have a successful workers' compensation?
I
think so too.
But it's not reasonable management action.
No, it's not.
It's not bullying, but the way that they did it was not reasonable.
Can I just say we're now 7 minutes over time and we're going to speak really quickly and say goodbye.
We're not. We're 3 minutes.
3 minutes over time, are we?
No, we got 3 minutes to go. Yeah.
Oh, we got 3 minutes to go. You told me we were behind.
I think we had 5 minutes to go. Yes.
I've been babbling. You've been babbling.
All right.
Okay. Thumbs up.
Yeah. Thanks for
See you
joining
later.
in.
Bye-bye.